Should judges rule based on the law or based on what pleases the president? Jamie Raskin just asked the quiet part out loud, and the answer shook the hearing.
5 minutes. Thank you very much, Mr. Chairman. Judge St. Eve, Judge Scudder, thank you for your testimony today. Federal judges and state judges both swear an oath to faithfully discharge their duties under the Constitution and under the laws of the United States. Judge St. Eve, should a judge ever decide a case based on whether their decision would please the president or any other public official?
I could say in deciding cases, I look at the law and apply the law, apply the dictates of the Supreme Court, and that's what we are directed to do.
That's right, and that sounds like the normal course of business. But we just found out last week that a federal district court nominee may have done precisely that. Before Florida State Judge Ed Artow was nominated in May by President Trump, he lobbied for his federal court nomination at the same time that he sat on a state court panel that heard Trump's case against the Pulitzer Prize Board, which Trump was suing because he disagreed with their award of the Pulitzer to the New York Times and the Washington Post. And the decision in the case was about a very narrow question of personal jurisdiction, which the court ruled upon. But this judge filed a concurring opinion in which he reprinted lots of Donald Trump's bold and capitalized letters about what a fraud all of this was. And actually, not only did he reach the merits of the case, saying that Trump had shown that the Pulitzer Board had remarkably acted with actual malice towards Donald Trump, but the actual malice standard set forth in New York Times versus Sullivan should be overturned by the Supreme Court. And the court, he said, should return to the common law standard in England, which allowed for people in public office to prove that they had been libeled by someone without showing any intent at all on just a strict liability standard. Quite a remarkable thing. I suppose you don't want to comment on that particular situation, but would you think it's improper for a judge to be rendering a decision in order to please a president who might then appoint them to the federal bench? Could I ask you, Judge St. Eve, first? I
am not familiar with that situation and don't think it would be proper to comment on somebody who's pending for a judgeship.
Right, and I would never ask you to do that, but let me ask you, Judge Scudder, abstracting from the facts of this case, is I've advanced them in a compressed way, and you can check it out if you're interested on your own. There's a lot of news coverage about it. But do you agree with what I think Judge St. Eve said at the beginning, which is that a judge should never rule in a way that is designed to please a public official as opposed to enforce the meaning of the law?
I do agree with that, and I think you recognized it in some of your comments that preceded your question, and that is embedded within the oath that judges take is we swear to decide and resolve issues without fear or favor. The independence of the judiciary is enshrined in Article 3 of the Constitution, and we take seriously the duty that you recognized earlier that Chief Justice Marshall pronounced in Marbury.
Well, I appreciate that very much. Can you describe briefly how the ABA ratings for federal judicial nominees worked before March of this year?
I can't. I can't, honestly.
Let me refresh your memory. I don't know whether you went through that process. But essentially, the ABA examined nominees and their backgrounds to determine whether they were qualified for the job and also had met the various ethical requirements of the job. And that existed since 1955, when the ABA began vetting nominees and used the present-day system since 1990 for the last 35 years. So we had a system in place that began under President Eisenhower to ensure that judicial nominees have the appropriate qualifications. In March, Trump announced he was no longer going to provide the ABA access to the materials they need to vet the nominees. And then just over 2 months later, he nominated one of his personal criminal defense attorneys, Emile Beauvais, to the Third Circuit Court of Appeals. And we learned yesterday the White House approached Beauvais to ask if he wanted to be a federal judge after he ordered the dismissal of corruption charges against Mayor Eric Adams. So do you think, or would the Judicial Conference take a position on restoring the ABA vetting system, or do you think it's just going to remain agnostic about whether it should be dismissed?
The Judicial Conference, to my knowledge, has not taken a position on that one way or the other. That is outside of the scope of the budget process that I'm here to testify about today. I'm happy to take that question back or put your staff in touch with staff if you'd like.
All right, I appreciate that. I yield back to you, Mr. Chairman.
Thank you for the gentleman. Isn't it an interesting coincidence that Eisenhower, the man who made a deal politically with Earl Warren for the endorsement and made him Chief Justice, is the guy that this started under? I would note, by the way, that I would likely get a 0 on a Bar Association endorsement for a judgeship.
You said Ike would?
I would get at least a 0.
Oh, but we would give you 100, Mr. Chairman. I don't think you have anything to be afraid of. So,
I thank the gentleman. We now go to the gentleman from South.
What Jamie Raskin did here wasn't partisan theater, it was a constitutional gut check. In one of the most important questions you'll hear in Congress this year, Jamie Raskin confronted a terrifying trend: judges being rewarded for loyalty instead of integrity. He laid out a real-world example of a Trump-aligned judge allegedly signaling fealty while seeking promotion, then forced respected former judges to say the truth out loud. And they did. Judges are not supposed to rule to flatter presidents. They're not supposed to audition for appointments. They're not supposed to weaponize the bench. Yet that's exactly what Raskin warned is happening when judicial independence collapses and loyalty replaces law. When the ABA vetting system is sidelined, when criminal defense lawyers become appellate judges, when fear or favor quietly becomes the norm. This wasn't about Trump alone. This was about whether the rule of law survives power politics. And the silence in the room said everything.